Good afternoon. Here we go once again discussing, go over Chapter 6 now, talking about the Constitution. And I think your guys' assignment maybe had to do with the Bill of Rights, if I'm not mistaken, for this particular chapter. So um, I like talking about this one. I don't know why. I just, our Constitution right now, as a nation, we've and as a form of government actually have survived longer than predecessors, of different forms of government. So our Constitution's held up, to the test of time, and under constant attack. We look at the attacks maybe on the Constitution today as maybe being unique, but they're really not. So it's been an enduring document. How much longer it will endure, I don't know. Again, it is under constant attack, and I wouldn't say it's been changed. The Constitution is still the Constitution as it's been written, but maybe the interpretation of it continues to undergo change, and those things may well serve to weaken or eliminate it eventually. We'll see. So. But it provides the framework, right? Absolutely, the legal framework gives the federal government authority to regulate certain business activities and whatnot. So, four key concepts are separation of powers, and this goes both lateral and horizontal. Meaning, lateral is between the various branches of government, the executive, legislative, and judicial, but also between the various levels of government, federal, state, local, right? The Supremacy Clause then says that the federal government and the Constitution really is the supreme law of the land. Okay, Contract Clause says that, laws made subsequent to a contract shall not change the nature of the contract. Word something like that anyhow. And the Commerce Clause, which is huge, and the Commerce Clause has been used to allow, I would say, the U.S. government to regulate lots of activities. So, separation of powers, right? This was huge. Our forefathers instituted this, and it was brilliant on their part that there would be checks and balances between the three branches of government. That they would look at each other and try to keep each other in check. Okay, federalism, separate and distinct roles of levels of government, right? So when we talk about that, people that were there was a federalism party, I think, at one point in time that really, held to the fact that each party should be really distinct at each level, should be really distinct and not have a lot of interference from the others. Again, the Supremacy Clause says the Constitution is the supreme law, and federal law over state law, when allowed. Preemption is just that federal law preempts state law. Okay. And state laws can be invalid then if they conflict with federal law. This may be important, this concept here a little bit, may be important in the Wyoming case that's in the discussions regarding the pond. So something some folks might want to look at. Contract Clause says the states can't pass laws that impact rights and duties under existing contracts. So, if there's contracts that are in existence over different things, states can't pass laws, right? This one's interesting, and I sometimes I don't know how some laws have gotten interpreted this way. There's some local cases, one regarding elk ranching here locally. I sometimes wonder some of the laws regarding our regulation of alcohol and whatnot at the state level and whatnot, that there's been some things that have happened there that probably in my opinion, but I'm certainly no legal scholar, would seem contrary to this, but obviously not according to our courts. But it doesn't apply to the federal government. So the federal government certainly can and does not apply in emergencies. So in the case of war, those types of things, certainly not. So we won't talk a lot about the Contract Clause. I think this is probably it. So I think if you know the definition of that, you'll probably do all right. The Commerce Clause, on the other hand, is huge, right? Commerce Clause basically says Congress shall have the power to regulate commerce with foreign nations and among the several states and with Indian tribes. That's kind of interesting. I'm humming because I'm kind of wondering, we've just recently, very recently, opened up relationships with Cuba, and a nation which we have embargoed for a long time, going way back to the 60s, so a long time, and yet I don't recall Congress ever meeting and discussing it. It's all been executive action that's been opening up some of the stuff with Cuba, and maybe it was authorized. You'd almost have to go back and see what the authorizations were, because oftentimes, Congress will pass laws authorizing the president to do this or to do that, and that may have been 50 years ago that's how it was passed. So regulation for, again, foreign commerce and also interstate commerce. And again, this is interpreted extremely broadly. Okay? It limits, the Commerce Clause limits state police power or the state's ability to maybe pass certain laws regarding the general welfare of the populace, and it also limits state taxation. So police powers, we define that as state legislation and regulation to protect the public's health, safety, morals, and general welfare. States are generally allowed to do that, but again, they're limited if it contradicts or goes against what federal law might be, and maybe we can take a look at. Oops, excuse me. I might hit the pause here and. Okay. So police powers. If a state law is contradictory to a federal law, the police powers, the federal government, again, should preempt that. Now, again, I get a little bit confused sometimes with what's going on nowadays, because we've had, for example, we've got federal laws that make the use of marijuana, for example, illegal, and yet several states have passed laws that legalize it in the state, which is contradictory to federal law. But at the present time, anyhow, we've said that the federal government has said anyhow, or at least agents of the federal government have said that they don't intend to enforce the federal marijuana laws. So I have to admit that for me this is confusing, and there's been some laws and rules and regulations regarding immigration that similarly kind of confuse me in how they're being carried out, but I may be getting political there, and I don't really want to do that. So foreign commerce, right? Federal government has exclusive right to regulate foreign commerce. Absolutely. States can regulate commerce if it occurs entirely within the state boundaries. Very, very, very narrow interpretation of what's within a state boundaries. If you look at I always try to remember the name of the case, but it's a farmer. I think it was in Ohio. I used to always think it was Kansas, but it's in Ohio, if I'm not mistaken. Grew wheat on his farm, and the purpose of the wheat was only to feed his family and his livestock. And yet, the ruling was that wheat was still subject to regulation. And I think it went back to the 30s, the Depression era, when they were trying to control production. It was still subject to the regulation of the federal government, because no matter how small of an impact, just the fact that that person was growing wheat might impact the markets for that commodity, and so it was subject to federal regulation. So it's interpreted extremely broadly. That's the name. Wickard Filburn is the case, if I'm not mistaken. So we can even kind of click on that and take us there, maybe. So, yep, 1938. So again, yes, it was in the during the Depression. Wickard, let's see, Filburn was the farmer, and Wickard was the Secretary of Agriculture. Yep. And again, they were back. They had trying to put stringent controls on at that point in time, wheat production and whatnot, they're trying to limit supplies and increase the prices to get some inflation instead of deflation. So interstate commerce defined, persons engaged in or activities affecting, and again, interpreted very, very broadly. Commerce Clause restricts state police power. That's kind of what we talked about there. The Dominant Commerce Clause, again, just setting up the dominance of the federal government over states in terms of those laws. Exclusively, so basically says that our federal government exclusively has the right to regulate, federal airports, docks, those types of things. Some of the transportation and whatnot, Local, it's becoming harder and harder to find examples of things that are strictly local. Dual regulation, there's a lot of that. If you look, for example, in Montana, we have a Department of Environmental Quality. It has a lot of regulatory authority that's similar to the EPA, we have a Human Rights Commission or a Human Rights Bureau that has a lot of similar duties that the EEOC has, or Equal Employment Opportunity, which is federal. And so there's a lot of dual regulation, and sometimes those groups, they work together, on certain projects and whatnot, no doubt. And sometimes, and usually it's okay if the state rules go further then. Usually there's not a problem with that. We all know California, for example, has more stringent emission requirements than the rest of the country, and California is instituting some more green requirements in terms of use of sustainable energy and whatnot, and the government for the most part says that that's okay. You just can't be less than. So state taxation is a form of regulation. It's limited also by the Commerce Clause. Apportionment just talks about how companies like Walmart and those that do business all around the world, how they apportion the amount of income that they might get per state in order to pay the taxes for those particular states. Because certain administrative costs and those types of things can get applied to the incomes and whatnot that might occur in that state. And it gets to be kind of complicated. Probably more of a tax situation, and how they treat it tax-wise is why that would be important. There has to be a sufficient tie or a nexus or a taxable site, as they mean the same thing. For states to pass taxes, there has to be a tie to legitimate state ends, I guess. So taxes can be set broadly. There's nothing wrong with that. There's nothing wrong with setting taxes broadly and saying we're going to have an income tax and we're going to use it for the general welfare. Same thing with property tax. And we've even ruled that we can have state. We've got taxes on hotels and whatnot then that are used to fund the Commerce Department and those types of things. Well, those are kind of specific. You're picking out a certain industry there, and really you're passing a tax on that industry, in this case lodging. And so there has to be a sufficient tie. Well, that's allowed because, the money then, I think, for lodging and whatnot goes to specific things within the state and used for those specific things. Might not be allowed if it was just a tax on a specific industry like that only went to the general fund. We do taxes on gasoline, but that's used for roads. Very much a tie there, we have separate taxes on tobacco and alcohol. Those might actually go to the general fund. I'm not 100% sure, but that might be allowed because the end result that the state's doing in taxing cigarettes or tobacco is trying to control or limit the use of those substances. And so, again, probably gets to be a little bit confusing in there, but it's just important for now that we know that there needs to be that tie or that nexus, and that it's interpreted, depending on the type of tax and then what those tax dollars are going to be used for. Do the protections of the Bill of Rights apply to businesses? That's interesting. The answer is, for the most part, yes. The answer is, for the most part, yes. And it doesn't mean, there's certain bills of rights that it's really tough for a business to, a business itself can't carry a gun, And so when you say the Second Amendment applies to businesses, yeah, but they can't really carry a gun. they can have them, I suppose on the premises or whatever, but that's an individual right. And so yeah, it's interesting, and yet some of them do apply, like First Amendment rights. The Supreme Court has ruled, and we'll talk about that in a bit. But the Supreme Court's ruled basically the First Amendment rights, do apply to businesses. So it's kind of a yes or no answer to there, but I would say generally yes. Amendments and basic protections are not absolute, right? So freedom of speech, freedom of religion, freedom of assembly, and the right to redress, and those things are not necessarily absolute. We have to balance that with public policy, and we'll talk about some of those exceptions as we go along. These issues, the fact that we have the Bill of Rights when we passed the Bill of Rights, and the purpose for that was to say, these aren't things that should be legislated. These rights are rights that are endowed upon everybody in the United States, and they might be subject to some balancing with the public policy, but we're going to let the courts decide that through due process and those types of things. And certainly they can vary during emergencies, and we'll talk about some of those. So the First Amendment, right? Freedom, religion, press, speech, assembly. Again, a lot of conversation going on about these freedoms, okay, and we might have some of these in our discussions. I find some of them kind of very compelling and very interesting. Obamacare introduced some mandates for insurance coverage that included coverage for certain abortifacients, if I'm saying that correctly, but pills anyhow that would early on cause an abortion to occur, that within the first week or so of a woman becoming pregnant. And yet there were some businesses that felt strongly that they didn't want to supply those because they had strong Christian beliefs. I think Hobby Lobby might have been the one that that originally contested that, and if I'm not mistaken, was successful. And other organizations that had strong religious ties also objected, and I'm pretty sure that they were successful as well. And there again, kind of gets back to, do businesses have a certain level of religious freedom? Well, maybe, maybe. On the other hand, we're also seeing businesses, though, that are being compelled to provide services like services for same-sex weddings, even though there's been several cases of those around the nation where a cake baker, for example, has been compelled. I think one in the state of Washington maybe has been already fined. They haven't paid the fine, but because they're still fighting it, and it'll eventually, it might eventually get to the Supreme Court, but they're fighting the case. But I think they've been fined over $137,000 simply for refusing to provide a cake for a gay couple that wanted to get married. And so there's a lot going on with with the freedom of religion as it pertains to businesses with, and maybe even without, really strongly held religious beliefs. Press, the press is, by the way, the only industry. That's kind of important to know. I think that's on the test, so But the press is the only industry that's really granted specific protection, okay, in the Constitution. Okay, we've always held that a free press is extremely important, but again, there's restrictions. We do have restrictions on obscenity and things like that occur for the press, right? Speech, same thing. Speech is generally granted to be free, but occasionally there's restrictions. There's restrictions on, can you say things that harm other people, maybe harm their welfare and do things like that? Well, maybe not. Right. In assembly, same thing. We're very open to assemble and have protests and do those types of things, but oftentimes you might add the words peacefully assemble, right? And one that's interesting that we take it for granted, but it's not something that's universal. Certainly in the world, it's not even something that very many people, other than people here in the U.S., even have the right to. The right to petition for redress. We can sue our government. Okay, we can and do sue our government on a regular basis, and that's redress, and it goes to the court, and we get to fight about that. So Okay, I probably got ahead of myself, but yeah, freedom of religion. The government shall make no laws establishing a religion, nor prohibit the free exercise thereof. I believe it reads something like that. And again, it's under some scrutiny right now. We're talking about in the employment discrimination too. Can you, if you're a strongly religious organization, can you refuse to hire people that might be of a different religious persuasion? It probably gets down to bona fide occupational qualifications. Okay, and we'll talk more about this when we get to employment discrimination. But yeah, the conversations about this just recently I have found to be very interesting, and I think they're going to get more heated and more even talked about more over the next several months or even years. So, unprotected speech. There is speech that's unprotected, right? Fighting words, words inciting violence, defamation. Yeah, and I'd love to tell you that these are black and white areas too, but they're absolutely not. Okay, so what makes up a fighting word, and who gets to regulate that? Who gets to do those types of things? And depends on the situation. Okay, they're very gray areas. Defamation, and there's libel and there's slander. Slander's the spoken type of defamation. Libel's the written type of defamation. I think we talk about that in later chapters. But that's where you use your speech, okay, written or spoken, to defame somebody, to make others think poorly about that person. And if that causes that person unnecessary harm, that can be illegal, right? So it's not protected. You can't go around defaming people. Now, can you express an honest opinion, or can you state honest facts about businesses or people? Absolutely. Okay. And then certain obscenities are unprotected. Okay, the courts have held that we can regulate certain things, right? You or I can walk around and mutter all we want. In our house, of course, we can say anything we want, use certain obscenities and whatnot. But we've got some restrictions on how like TV and those types of things can do that. And ruling here in 1964 by Justice Potter Stewart, when they were talking about regulating obscenities. And, TV was just kind of getting going in 64 and stuff. And so, basically he says, it's hard to describe what's obscene, but he says, I know it when I see it. And, I can tell you in my life, it was, for example, I think sometime in the mid-60s, maybe late 60s, that they would show a bedroom, man and a wife's bedroom with one bed. Okay. Prior to that, any bedroom scenes involved twin beds, as if married couples slept in twin beds, even though, generally that wasn't the case back then in real life. But on TV, they set this standard of prudeness, maybe. That was interesting, and obviously those things have really changed. And to say a hell or a damn even back then on TV would have been, not good. And now, I think even in regular TV, occasionally you'll hear the F-bombs and whatnot. So, freedom of speech. And we're still on the First Amendment, right? The overbreadth doctrine gives the right to challenge the law, though not directly affected. Remember, we said that you had to have standing to sue, and you do. Okay, in just about all cases. But the overbreadth doctrine, especially when we're talking about freedom of speech issues and those types of issues, allows other places to sue on behalf. Maybe if a group doesn't have that ability, I think we see newspapers and publishing and press types of places that use the overbreadth doctrine to sue, oftentimes for freedom of information requests and those types of things. They're not directly affected by, getting that information, but that information should be available maybe to the public, and so they have the right to challenge. Commercial speech, and I put down here in the bottom, I'll go to that first. Huge recent court ruling. It's been a couple years now, but it was called Citizens United. encourage everybody to just look up Citizens United. If you Google that and court ruling, you know, you'll find what it's talking about. And that was the Supreme Court. It went all the way to the Supreme Court, and the Supreme Court said that, you know, corporations do have a right to certain levels of free speech. Before that, they were restricted in how they could help fund campaigns, I think, for individuals. And the court said, you know, maybe that's not right. You know, corporations maybe should have a right to help pay for ads and those types of things. And there's still lots of discourse and lots of discussion about that particular issue. You know, folks have been critical oftentimes of the Supreme Court for making that decision, saying that, well, that's, you know, leading to corporations taking over the world, et cetera, et cetera. So, again, commercial speech, it protects corporations, companies, protects the listener and the speaker, right? And includes freedom of information. So, it's still on the First Amendment, the press, right? You know, our forefathers recognized that the press was to organize scrutiny of government. You know, they were the foil. That was part of their job, was to keep track of those types of things. Okay, freedom of press is not absolute. There can be prior restraints, and some of those again are like on maybe defamatory issues, obscenities, and those types of things. But for the most part, there aren't a lot of prior restraints. Okay. Here's, you know, defamation and obscenity, like I said. In other words, you know, the papers can write things and they may be challenged about it. You know, they may get in trouble too, right? But the idea here is that, you know, other than maybe some obscene things and some defamatory things, we want the press to be pretty free to write and to scrutinize the government and do those types of things. They're kind of the fourth rail, maybe. To defame a public figure can be bad if there's actual malice involved. So again, papers and the press are kind of restrained from doing that to a certain extent if there's a malice towards that person. Can you write all kinds of bad things about political candidates and people in office? Absolutely. Okay, as long as you believe them to be true and whatnot, sure. You can back it up, you know. If you were saying bad things about a political candidate that were completely untrue, yeah, you might get in trouble then, because then we get back to defamation and malice in that case. You know, if you were using your press, whatever that might be, in order to, you know, push to eliminate somebody's campaign, do something like that, that could be malice. So, yeah, here we go. Second Amendment. Most of us in Montana hold this one near and dear. It's something that we feel is important to us, and that's the right to possess guns, right? Let's see. And the amendment was written in kind of a strange way, because it talks about, you know, a well-regulated militia being necessary to the freedom of a nation, comma, or period, you know, the rights to bear arms shall not be abridged. Something to that effect. So, there really haven't been, you know, in spite of that, few court opinions, and because, you know, there haven't been, right, widely, because we've throughout the country, for the most part, accepted the fact that we do have a right to bear arms, right? And yet there have been locales and states that have put maybe increasing pressure on putting in some gun controls and whatnot. And some locations have far more severe gun control than, you know, Montana, for example. Okay, but there haven't been a lot of decisions, not a lot of them that have gone, I shouldn't say, there haven't been a lot that have gone to the Supreme Court anyhow, right? In 2008, though, and I think this was a decision in Washington, D.C., it said individuals may have handguns in homes for self-defense. It really upheld that. Now in McDonald versus Chicago, and it was nearly that same time, I think, the decision basically by the Supreme Court then said that having a gun and having a right to bear it and do those types of things is basically a civil right here in the United States. It's something that our forefathers felt strongly about and put it in the Bill of Rights, and therefore it's a civil right. And that decision may, in fact, put to rest a lot of other court challenges. We'll still have court challenges because cities and states and whatnot will still continue to try to plug away at maybe enforcing more rigid gun control types of laws, you know, especially with some of the gun violence that we do see. So This was widely considered to be a fairly narrow opinion. I think the justices even said, you know, just because we say that you have a right to have a gun, it doesn't mean that you can have a gun, any type of gun, in any particular place. Meaning that, you know, we might still be able to restrict certain types of guns, and certainly we can restrict where, you know, you might be able to carry those. So worried that it was a narrow opinion and that it might increase some litigation that would go on. Fifth Amendment's got a lot of stuff in it, okay? Protects criminals, protection in the criminal law. We've all heard, I'm going to take the Fifth. Okay, we've heard that recently with some folks that have been called in front of Congress, in fact. Some in conjunction with Secretary of State Clinton's emails. You know, we've had some folks that were called to testify there that have said they would take the Fifth. And taking the Fifth means that you can refuse to testify if it'll incriminate yourself. Okay, you can't refuse to testify about things that might incriminate others. You know, that can be obstruction of justice, perhaps, and you can't, you know, yeah, you can't refuse to produce documents and those types of things, because certainly that would be obstruction of justice. So, but you don't have to testify or give testimony that might incriminate yourself. Okay, the Fifth Amendment also sets up due process. It talks about the processes that we have to go through and the rights that we have if we are, you know, accused of doing something, right? And the Fifth Amendment also, and these almost seem like they're not related, but it also has the eminent domain clauses in it, where we've said that governments, both local, federal, state, can take possession of, that's not the best terminology, but the government can take possession of property, private property, for public use. And you know, originally this was deemed, of course, to be for things like roads and railroads and those types of things that, you know, if there were, you know, greater good of the government being necessary and we could do those types of things, and that would be important, but that the folks that would receive just compensation, okay? I put here that the public use definition's been expanding, and when we talk about property rights and whatnot a little later, you know, we'll talk about some of the decisions regarding eminent domain and how, you know, public use has now come to mean even allowing private companies then to come in and be able to build businesses, buildings, those types of things, because it's for the public good in the end, is how the definition might be interpreted. And there's arguments about that, both pro and con, and again, we'll talk more about that when we get to that part. 14th Amendment, also called the incorporation doctrine, it talks about due process, and basically when we call it the incorporation document, it says, you know, that these rights are going to be held over to the states. The states are going to be required to adhere to these too, and so the processes and whatnot, you know, even if it's a violation of state law, not federal law, you know, states still have to file or still have to follow these due processes, right? Talked again about eminent domain, you know, talks about the substantive property rights that people have. Again, the Fifth Amendment's the federal. The 14th Amendment, it says state and local. What that means is that it incorporates everything in here over to the states in their dealings with those types of things, and that's why it's also called the incorporation document. So it has to do with due process, as is the Fifth Amendment, right? So remember, those two amendments have to do with due process. Equal protection. This is one that I always struggle a little bit in trying to find great examples, and I wish I could. I still struggle, but there's three levels of standard that the courts apply to laws and how they are enforced. Okay. And the first is minimum rationality, and basically minimum rationality says that you know, a law is going to pass this test if it, excuse me, and I'll pause again here. It says that a law is going to pass this test if it has just meets a minimum requirement of serving the national interest. You know, what would be an example of this? You know, laws that regulate when we talk about waterways. Okay, nobody would argue that, you know, regulating the big navigable waterways, you know, making that water clean and you know, as clean and whatnot as possible, fits, right? It's minimally rational, and we would probably all agree that the federal government, you know, the laws regarding that would fit those interests, right? And so we pass those, and that's fine, and that's dandy. Laws, you know, maybe regarding having a voting age of 18. Okay, it serves the interest of the nation as a whole, kind of minimally rational, right? Quasi-strict is the next level up. These things aren't necessarily in the order, and that says that we're gonna view things with a little bit more of a strict. There has to be a compelling, I believe, is the term that they use here, you know, national interest for doing this. I find this one, again, kind of tough to talk about. Not talk about that it's politically correct or anything, but just finding good examples. A lot of these are applied to sex-related or gender-related things. There's discussion right now going on in the services, you know, about women's roles in combat. Okay, for the longest time, and we would use this rationality, the quasi-strict scrutiny, to say that maybe women shouldn't have a combat role. And one of the reasons, going back to ancient times, was that women need to stay home and have babies. Okay, going back to ancient times, but that's something that's still carried forward too. And you know, some of the questions now regard, you know, their strength and abilities versus men and whatnot, and also how it would affect having if you will, co-educational combat units. You know, what effect that might have on a, you know, fighting man's ability, or whatever, however you want to call that, right? And so that one's kind of been subject to quasi-strict scrutiny. So we've allowed discrimination, basically, is what we're saying there, is that we've allowed discrimination in saying that you know, men are going to make up combat units. Okay, then you get to gun laws too, have somewhat been subject to this quasi-strict scrutiny. That again. There's going to have to be a compelling state interest for them to allow, you know, certain restrictions on gun laws, because we hold gun rights to be near and dear, you know, here in the United States. And so, you know, that's basically the level of scrutiny. Now, strict scrutiny, there has to be there's where they use the compelling. So I might have the compelling a little bit wrong. I don't remember what the quasi was then. That maybe it's a strong reason. Pick your adjective there if you want to. Okay, so back to strict scrutiny then, there does have to be a compelling state interest. So that means it's going to be, you know, it's got to be something that's really, really strong. The first case that had to do with this had to do with interring Japanese Americans during World War II. And the court allowed that to happen. Okay, so clear discrimination, right? Clear discrimination. And yet the court felt that given the circumstances, that met the standard of strict scrutiny, that we've applied strict scrutiny, it meets our standards, and so we're going to allow that to happen. Okay, in normal circumstances, you know, would never have happened, right? And didn't obviously before the war, and certainly didn't after the war. So that's kind of I guess, how you'd describe the three of those. I wish I was better at it. Equal protection issues, right? Legislative apportionment, how we you know, set it up to apportion. You know, for example, Montana gets one total congressperson, 3 or 2 senators, but they're not apportioned, but 1 congressperson, right? Real estate and racial segregation. What a nasty part of our history. I mean, literally, they used to set up restrictive covenants and whatnot that would say minorities can't live here, you know, those types of things. And so it was a pretty disgusting part of our past, and obviously, you know, those have been fixed, hopefully anyhow. Rights of legitimates and illegitimates, you know, and we don't even think about that today because so many children now are born out of wedlock. But in the day, you know, that used to be a big deal, name and carrying on the name and rights and the estates and just all kinds of things. So used to be a big deal. It's less of an issue now. Jury makeup, right? Can we maybe eliminate prospective jurors because of sex or maybe even because of race, depending on the nature of the case, right? Can we do that? Yeah, maybe. Voting requirements, lots of talk about those types of things. You oftentimes hear conservatives saying, yeah, they ought to be able to show an ID, and you hear liberals saying that we're just, that the conservatives are just trying to eliminate voting rights and whatnot. So welfare residency. So, do you have to be a resident of the U.S. to get some welfare, right? Rights of aliens to schools, those types of things, property tax to finance schools, those have been widely accepted. So timeline of some of these cases, I don't know that you really need to worry too much about that. The Fair Labor Standards Act, we're going to talk a lot about when we get to employment issues, so I don't think there's anything there. So got through it, a little slow, sorry, got interrupted there a few times, but if you're ready, again, test this Sunday, so good luck and have a good week.